My attention drawn to a press conference of the new Attorney General and Minister for Justice on Wednesday, February 2025. The press conference, the Chinese ought to provide reasons for its discontinuation of certain criminal cases filed against some persons, most of whom are leading members of the National Democratic Congress, NDC, persons who served in the NDC government that exited office in January 2017. As the public will observe, throughout my tenure as Attorney General of South Africa, I never made any comment or passed judgment on the work of any of my predecessors in office, even though I was often at the receiving end of many unsavory remarks from sections of the populace, particularly personalities in the NDC. Since leaving office, I have also stayed clear of subjecting the work of my successor to any form of the brush of the Attorney General from warranted scathing attacks, as some members were subjected to similar disparaging attacks under the guise of Dr. Ayeni's strained exercise of assigning reasons for decisions he has taken as Attorney General. I consider the attack on the judiciary as part of the stratagem of the NDC to blame others for their resolve long before they assumed power to clear all of John Mohammed's appointees of any criminal liability or past decisions are in furtherance of the resetting agenda of the NDC. The material facts will bear this out. Dr. Ayeni was sworn in as Attorney General on Wednesday, 22nd January 2025. On Friday, 24th January 2025, he caused to be filed a notice of abandonment of the appeal by the state in Republic vs. Atuforsen and two others. On Tuesday, 28th January 2025, he withdrew the case against Dr. Stephen Opuni and two others, resulting in the complete whitewash of their crimes by an acquittal and discharge through the back door. On 29th January 2025, he entered another withdrawal in Republic vs. Okosuan Bofo and another, again resulting in an acquittal and discharge of the accused. On 30th January 2025, Dr. Ayeni withdrew two different cases against Dr. Johnson Pandit Iselva, resulting in his acquittal and discharge in one and a discharge in the other. There were more withdrawals and non-prosecuted to be entered by the NDC government through the Attorney General in the subsequent days. Irresistibly point to only one conclusion: a calculated, preconceived ploy on the part of the NDC to wipe out all criminal cases pending against its leading members and officials of the John Mahama government and clear them of wrongdoing not by the courts but through their Attorney General. Remarkably, there is no precedent for this kind of conduct in the Fourth Republic. Throughout the two 8-year terms of the NPP government, no Attorney General appointed by either President J. Kufuor or President Kufuor withdrew criminal charges or filed non-prosecuted in cases involving leading members of the NPP or senior members of the government. At the time the NPP assumed office in 2017, all the cases filed by the SR NDC government against some ministers of the Kufuor government and other appointees have been contested fully in the court and won. We secured acquittals through the court and not by resorting to delayed tactics in the hope that the Kufuor appointed Attorney General would come and withdraw the cases and procure an acquittal. I speak from experience as I personally that it is clearly unprecedented for an Attorney General to hold a press conference and subject his predecessor in office to abuses and peddling falsehood in the manner displayed by Dr. Godfred. I'm constrained to set the record straight, to unveil the half-truths and manipulation of facts for what many Ghanaians to decipher the true intentions of the NDC government acting through the current Attorney General and withdrawing charges against leading members of the NDC. One, it is necessary to indicate at the outset that the decision to charge a person with a criminal offense, especially the high-profile cases at issue, which have serious implications for the public purse, involve a prosecutorial discretion exercise pursuant to painstaking investigations conducted by duly authorized investigative authorities of state, inquiries and extensive deliberations by career prosecutors in the office of the Attorney General, who indeed proceeded to conduct the cases themselves. I continue to be grateful for the advice I received from the hard-working attorneys at the AG's office, investigators and my able deputies, Mr. Afretia Yeboah and Mr. Nasnoma Dapa, on the cases we personally initiated in office and the many others that have been commenced by my distinguished predecessor, Madame Gloria Ifua Ekufu, which will continue. We cherish the robust discussions and debates we had whilst professionally moving forward with each of those cases. The nation would note that Dr. Ayini and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayini and other NDC personalities were looking at the same set of facts to come to different conclusions, informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as drawing those cases, the only consideration has to be in the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayini will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayini's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic vs. Kassia, Tuforson, and two others, is highly disingenuous and rather unfortunately recaps the series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayini, who is the subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayini at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the high office of the Attorney General and Minister for Justice of the Republic. The facts relating to allegation by Dr. Ayini that I interfered with an accused person in the ambulance case are well within the public domain and have been adumbrated in court proceedings. The record shows that there has been a judicial determination of that unfounded allegation frequently made by foot soldiers of the NDC and other uninformed people. Shockingly, Dr. Ayini, the current Attorney General, ignored this fundamental fact in his 10-page press statement and over an hour conference with the media for the simple reason that he knew that his allegation had been flatly debunked by the court when same was put to strict scrutiny. If you would recall, the accused person in the ambulance trial filed an application for mistrial, hanging same on the alleged interference with one of the accused persons. On 6 June 2024, the High Court quorum or sitting through or presided over by her Ladyship Justice Ifia Godfred dismissed the application. You would all remember the learned Justice of the Court of Appeal, who served as an additional High Court judge, said that she had listened to the tape in question about 10 times and found nothing to warrant a mistrial. Specifically, she stated at page 24 of her ruling, and I quote, "After listening to a conversation between the third accused and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on Exhibit C AF2. These words were uttered by A3 at about minute 09 to 10, minute 10. In the same vein, the declaration that A3 was innocent and was going through ordeal, but was being asked to help make the case to the AG better, was not made by the Attorney General, but was made by A3, to which the Attorney General responded at minute 10, second 20. And I quote, "I am not asking you to help me at minute 10, 2nd 30. The statement that you and I have been meeting at my cousin's place at minute 10:45, etc., were held closely together with A3's alleged attack of conscience did not proceed from the mouth of the attorney general. End of quote. The judge proceeded to state at page 32 of a ruling that the third accused, and I quote, I'm quoting, the third accused by any stretch of imagination is seen to be the one. The third accused by any stretch of imagination cannot be seen to be the one procuring new evidence or cow by conversation. End of quote. In the face of this clear judicial pronouncement of no wrongdoing as to warrant a mistrial, it completely defies logic and good reason why the Honorable Attorney General of Ghana will say to the public that I was culpable of what he describes as a disgraceful and unethical conduct in the ambulance trial. Ghanaians want to know rather how the current Attorney General, Dr. Dominic Ayine, will deal with the complaint of professional misconduct pending Nigeria Legal Council against him, but no less a person than the former Chief Justice of the Republic. Ladies and gentlemen, in a chilling twist, the nation heard Dr. Ayine confessing to speaking with lawyers for the defense and engaging them on the cases that were pending against leading members of the NDC before exercising his discretion to file no prosecution or withdraw the charges. He indicated that in Republic versus Jachikwesi, the lawyer for the accused expressed an inclination to go on and prove the innocence of his client, and therefore he decided to enter no prosecution. Especially, what this betrays clearly is that the exercise of Dr. Ayine's discretion to continue the prosecution of cases or not is informed principally by the disposition of counsel for the accused in cases that the Republic is prosecuting against their clients. Thus, if counsel for the accused is in a position to strongly defend the interests of his client in court, the Attorney General of the Republic will not enter the prosecution. Where the counsel for the accused are not convinced about the likelihood of a success of their defense in court, Dr. Ayine would immediately enter a no prosecution if the prosecution has not closed his case, and a withdrawal if the prosecution has closed his case, so that an acquittal and discharge will be secured. As I will show in an examination of each of the specific cases cited in Ayine's first statement, the Honorable Attorney General quite comprehensively relied solely on the case for the defense before exercising his discretion to discontinue the actions. He did not engage in any meaningful consultation with the prosecution's division of the Office of the Attorney General before instructing the filing of the withdrawals and no prosecution in the cases against senior members of the John Mahama government and other leading members of the NDC. The dates of filing of the said processes buttress the assertion I make, and I've referred to them already. I challenge Dr. Ayine to show any memorandum presented to him by the prosecution's division of the Office of the Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecutions, the DPP, before discontinuing the cases. You can be assured he cannot produce any. Listening to Dr. Ayine, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law on the subject matters in question. It is for this reason that the claims of alleged defects in the various charges only re-echo positions attributed by the defense counsel throughout the various proceedings. In effect, Dr. Ayine came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel on the charges their clients had been charged with. The media would notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter the prosecution and withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interests of the Republic and the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayine that he did not consult the former president John Dramani Mahama before taking the monumental decisions to discontinue the criminal cases. The cases involved the loss of colossal sums of taxpayers' money, and some related to the banking sector crisis, which affected the Ghanaian economy. The people of Ghana should indeed be extremely concerned and afraid by the vesting of constitutional authority in a person who can discontinue the prosecution of such important and high-profile cases without discussing with the President of the Republic and members of the Cabinet. Even Defense Counsel, according to him, they consulted. How much more the President? Ladies and gentlemen, we ought to ask ourselves, is it true that Dr. Ayine did not consult the President or his Cabinet about the decision to discontinue the various criminal proceedings? A careful examination of the facts shows that this claim is palpably untrue. The nation has not forgotten the loud claim by President John Mahama and the NDC that the MPP rather was responsible for a collapse of the banking sector crisis. And that on assuming power, the John Mahama government will restore all the banking licenses which were revoked. The withdrawal of the cases in question is only the first step of the clearing of whitewashing process of those whose acts led to the crisis that plagued the banking sector. Ghanaians are certainly more discerning than the NDC and Dr. Ayine think. I proceed to examine Dr. Ayine's reasons for withdrawing some of the criminal cases Dr. Ayine mentioned in his first statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betraying the questionable motives for his actions. First is the Republic versus Mr. Atufosin and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense, as the defense of Dr. Atufosin. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's prosecutorial authority under Article 88.4 of the Constitution is exercised by himself or, in a quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 at 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayine, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayine characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles reporting to the ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at the time that the period for supply of the ambulances and the contract had even lapsed, Dr. Atufosin, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller Secretary General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. Big C General Trading Limited, the suppliers to the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Alen Semifia, described the vehicles as ordinary vans, not fit for purpose. The defects were so irremediable that from the time the vehicles started arriving in December 2014 to January 2017, when the SR John Mahama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances, and the Mahama government is back in power. I am of the honest view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayine's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayine was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Atuforsen, stand to lose by the termination of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for the discontinuance of the appeal by Dr. Ayine was that he did not wish to deepen the woes of Dr. Atuforsen any further. Republic versus Ofosuampo for another. Dr. Ayine did not advance any reason whatsoever for the withdrawal of this matter, save that he was on record as counsel for the defense. I have already pointed out above the absurdity of such a position, and I will not recount. The self-serving nature of Dr. Ayene's decision is too apparent for the people of Ghana to see. Republic versus Collins, Dauda, and 4 others. The reason advanced by the Attorney General for the entry of non prosequi in the case filed against Mr. Collins, Dauda, and 4 others for their roles in the Sagleme housing scheme is that, in his view, the charges were defective. He claimed that the prosecution wrongly charged the former Minister Collins Dauda with the offense of misapplying public property, i.e. funds, in the sum of $200 million United States dollars. In Dr. Ayene's view, the prosecution should have taken into account the fact that part of the $200 million was used to construct their houses at Sagleme. With the greatest respect, this analysis by Dr. Ayene portrays a complete misapprehension of the ingredients of the offense of misapplying public funds. The offense of intentionally misapplying public property consists in wrongly applying public property, which is defined under the Public Property Protection Act of 1977, SMC Decree 140, for a purpose other than as lawfully approved. It is different from the offense of willfully causing financial loss to the state, whose defining ingredient is the actual loss occasioned the state through one's lawful act. In this case, Mr. Collins Dauda was charged with the offense because he intentionally misapplied the sum of $200 million for the construction of 1,412 housing units instead of 5,000 housing units lawfully approved by the Cabinet, the Parliament of Ghana, and the Public Procurement Authority to be constructed. To the question of how much was disbursed by the state during Collins Dauda's tenure as Minister for Western Housing, or the exact amount spent on the buildings when he was minister, is immaterial. The real question is whether Collins Dauda authorized the application of the sum of $200 million for the purpose lawfully approved for the project, i.e. the construction of 5,000 housing units. The answer to this question can only be in the negative. I say that in any event, if the Attorney General with the considered view that the sum of $200 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only one out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayene does not fault and did not talk about? In the greatest respect, the state should be seriously worried if her Attorney General demonstrates such ignorance of the basic principles of criminal law and the ingredients of offense, which border on the protection of state funds or public property. The second factor cited by Dr. Ayene for the withdrawal of the Sagleme case is the alleged failure of the prosecution to charge other ministers who took office after Collins Dauda left office. This is another palpable falsehood. The state charged all those whose roles in the Sagleme housing scheme implied criminal liability. This included Kweku Ajimamesa, who signed and authorized the payment of money and who was John Mohammed's Minister for Western Housing after Collins Dauda left office until January 2017. It also included a Chief Director, Alhaji Ziblim, who was in office until 2017, covering a part of the tenure of Mr. Atachia as Minister, and signed and authorized payment of money. Dr. Ayene raises issue with the failure to join Honorable Samuel Atachia as an accused person in the matter. It ought to be made clear that the prosecution of crime is not an arena to achieve political equalization. A careful check on the fact would have disclosed to Dr. Ayene that Honorable Samuel Atachia never authorized any payment for the Sagleme project. Mr. Atachia was rather the one who called attention to the bizarre circumstances of the project and wrote a letter seeking the advice of the then Attorney General, Mr. in or about 2019 for an urgent termination of the contract, a decision which stopped the state from unnecessary financial hemorrhage. The sum of $5 million that Dr. Ayine alludes to was authorized to be paid by the then Chief Director, Mr. Solomon Asola, and not Mr. Atacha. The decision by the prosecuting team not to charge Mr. Solomon Asola, but rather to use him as a prosecution witness, was because an examination of the record showed that Mr. Asola, in truth, tried to save the Sagremen housing project from total collapse. The sum of $5 million was authorized by Mr. Asola to be utilized for the project to save the project. Further, he assisted in shedding light on the relevant parts of the project. Hence, the prosecution's decision to use him as a prosecution witness. Prosecution of Dr. Johnson Pandit Isiama. The narration given by the Attorney General about why he is continuing the two different cases against Mr. Johnson Pandit Isiama again disclosed a litany of untruths, half-truths, and a skillful manipulation of the facts. Be that as it may, as it is with any manipulation of facts, the truth is always laid bare on being subjected to careful analysis. The first case involving Mr. Dr. Johnson Isiama Pandit, Dr. Johnson Pandit Isiama, is the Republic versus Pamela Dufour and others, the Unibank case. This case involved an approval by Dr. Johnson Isiama of the sum of 450 million Ghana cedis for the benefit of Universal Merchant Bank, UMB. Part of that sum was 300 million Ghana cedis, which was an unsecured facility approved by Mr. Johnson Pandit Isiama for UMB for the benefit of Unibank Ghana Limited. The sum of 300 million cedis formed the basis of a charge of making approval in contravention of the Bank of Ghana law. The remaining amount of 150 million Ghana cedis formed the basis for the offense of willfully causing financial loss to the state. It is necessary to state that contrary to Dr. Ayene's claim, the sum of 150 million Ghana cedis to date remains unrecovered. I must indicate that I find the line of thinking of Dr. Ayene that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid, very strange and insupportable in law. Also, an amount paid in violation of the law, when subsequently recovered, does not clear the person who gave the approval to be made of wrongdoing in the first place. The anchor of Dr. Ayene's explanation for discontinuing the case against Johnson Pandit Isiama is a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, reported as Dr. Ayene stated, and I quote him, recommended that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists. No such memorandum exists. I do not recall receiving any such memo from the prosecution's division. I challenge Dr. Ayene to produce such a memo for the examination of the public, as he has started saying to the public at a press conference conducted by him as a basis for his impugned actions. Curiously, when probed further on that issue in the question session of the press conference, Dr. Ayene claimed that I might have disagreed with the memo, and that is yet to know the exact reasons I made or the exact comments I made on the memo. This is bewildering and thus gave doubt on Dr. Ayene's assertion that a memo was presented to me on the issue. Will my comments on the position I took on the memo not be expressed on the memo, as is usually the case in every public service institution? How can Dr. Ayene see the memo but not see my comments in the memo? Clearly, the Attorney General set out to throw dust into the eyes of the Ghanaian populace, who, in his view, are a bunch of unethical people. Ghana deserves better than the tears of Dr. Ayene. Assuming for argument purposes that the memo was prepared for the consideration of the former Attorney General by some state attorneys whose ranks the current Attorney General does not specify, and on a date he does not indicate, is such a memo, I ask, binding on the Attorney General? is the view of the state attorney binding on the attorney general. Dr. Ini himself alleges that he had some discussions with the DPP before withdrawing the cases in question, and that when he disagreed, he made it known to the DPP. Was the DPP's view binding on Dr. Ini? I asked. I further asked, was it not his view, Dr. Ini's view, of the charges he withdrew, which prevailed? If Dr. Ini could form a view of the charges he withdrew from the court, in spite of what the DPP told him, how can he castigate Godfred in the media for whatever views Godfred took on a memo allegedly presented to him by some state attorneys who Dr. Ini cannot name on a date he cannot specify, and affecting some accused persons, again, he could not specify. And I say this because there are 6 accused persons in the matter. The question is, did the memo touch on all the accused persons? Dr. Ini feels indicate. I say that Dr. Ini should, with the greatest respect, be bold to accept full responsibility for his action in withdrawing and filing no prosecutor in all the cases, rather than purporting to blame former Attorney General for his decisions. Republic versus Johnson, Pandit, Isiama, and 5 others, the Union Bank case, the UT Bank case. Dr. Ini lumps up the 2 cases against Johnson's Isiama and contends that the alleged memo presented to the former Attorney General, my good self, which discussed the amount of 450 million Ghana cedis, the subject matter of charges against the gentleman in the Union Bank case, also covered the UT Bank case. This is another falsehood. The sum of 450 million Ghana cedis was in respect of only the Union Bank case. The UT Bank case involved the grant of approval by Dr. Johnson Isiama of 460 million Ghana cedis facility to UT Bank in violation of the single of the goal limit. Be that as it may, it suffices to note that Dr. Ini provides absolutely no justification for a withdrawal of the charges in the UT Bank matter, save the allegation that an alleged memo was presented to me. It is also important to note that the Attorney General considers the simple fact that the prosecution had closed its case in the UT Bank case. Thus, by virtue of the notice of withdrawal filed by the Attorney General, Dr. Ini, Johnson Pandit Isiama was acquitted and discharged of the crimes that he had been charged with. Dr. Ini therefore secured through the back door a whitewash and clearing of the sins of Johnson Pandit Isiama forever. Republic versus Stephen Opuni and 2 others. The reasons given by the Attorney General for the withdrawal of the case against the 3 accused persons in the Stephen Opuni case and the consequential whitewash and cleansing of sins through an acquittal and discharge again recounts the misconceived perspective of defense lawyers on the charges. That case involved a loss of 271 million Ghana cedis to the state. Once again, the media would observe that the Attorney General only presented to the public the series of stories that had formed the line of defense of counsel for the accused, but completely abandoning the formidable case brought by the prosecution. The Attorney General completely disregards the fact that the prosecution had been adjudged by all the courts in the Superior Court's attention, the High Court, Court of Appeal, and the Supreme Court, as having established a case for the accused persons in that Opuni case to answer. Indeed, Dr. Opuni had closed his case. Saidu Agogo had called about 10 witnesses. Dr. Ini, in the face of the holdings of the various courts, that there was a case for the accused persons to answer in respect of the over 27 charges filed in the Opuni case, proceeded to embark on a scathing attack on the work of the prosecution's division of the Office of the Attorney General, over which he is now superintendent, as a ruse to justify the withdrawal of the case. The simple question that begs for answer is, why would the Attorney General, who is supposed to be acting in the interest of the Republic, be arguing strenuously in favor of the Defense Counsel and against the Republic, when all the Superior Courts had stated that Dr. Opuni and 2 others had the case to answer? If the new Attorney General was with the view that the accused had a strong case and would be acquitted, why did he not wait for the accused to establish this through a trial? Is it the case that counsel for the accused told him, after his extensive discussions with them, that we are not sure of securing the acquittal of their clients, and therefore they would prefer the Attorney General to bail them out, to a withdrawal of the charges. Fellow Ghanaians, the purported rationalization of the government decision to withdraw the Opuni case, the Attorney General most bizarrely attacked the integrity of a retired Justice of the Supreme Court, Justice Clemens Koyeniba, and the Honorable Chief Justice, albeit unjustifiable. Dr. Ayine claimed that a perjury application filed by Dr. Stephen Opuni against a witness was not heard by Justice Koyeniba, and that, in his words, this is most unacceptable. Regrettably, this is another falsehood Dr. Ayene's press statement. The trial court ruled on the application. The applicant proceeded to the Court of Appeal by filing a notice of appeal. I repeat that the tendency of an Attorney General to make untruthful allegations against the prosecuting team and judges sitting on cases being prosecuted by his office is highly unprofessional. What we see, and this is exactly what we see from Dr. Ayene 3 weeks into his tenure. His actions constitute an attack in the very office he is now head of. Dr. Ayene stated further in his press statement, and I quote, "When in accordance with law and practice, Justice Anochi Jima decided he was going to hold a de novo trial in the same Opuni case, he was instantly transferred to Kumasi, and the case was allocated to a new judge who then proceeded to advocate proceedings." End of quote. This is another plain falsehood, and a rehash of the unfounded allegations made by NDC commentators in the media space. If Dr. Ayene had taken pains to examine the file in the Opuni matter, as he should have done, he would have found that it was not a new trial judge who adopted proceedings for the trial to continue. The then Attorney General, my humble self, was compelled to file an appeal against the order of Justice Anochi Jima for the proceedings to start de novo or afresh after they closed the prosecution's case and the defense had opened their case. The Court of Appeal allowed the Attorney General's appeal and ordered that the proceedings be adopted before the trial court. It took about 3 months for the appeal to be heard and determined. Before the conclusion of the appeal, the Honorable Chief Justice, in exercise of her powers under the Constitution, at the time that the proceedings of the Opuni matter had effectively been stayed due to the pendency of the appeal at the Court of Appeal, transferred the trial judge, Justice Anochi Jima, to the High Court, Kumasi. At the time that Justice Anochi Jima indeed had not even started hearing the matter at all. The display of unfamiliarity by the current Attorney General of facts regarding cases he withdraws from the various courts and speak about in the media is shocking. Ghana must be seriously worried. Ladies and gentlemen, in conclusion, I say that I deem the press conference hurriedly assembled by the Attorney General, Dr. Dominic Ayine, as a knee-jerk reaction to genuine concerns raised by well-meaning Ghanaians and the attempt by the NDC government to whitewash the crimes of persons who served in the NDC government, and as far as the law would allow, close to them perpetual immunity from being prosecuted for crimes committed against the Republic of Ghana. The posture adopted by the Honorable Attorney General threatens to undermine Ghana's democratic and good governance structures. I am, however, reassured by the fact that Ghanaians are discerning enough to discover the illegitimate motives for the discontinuance of the cases in question. The President, through his Attorney General, has in a spectacular fashion become the clearing agent to indemnify their allies who have duly been put before the courts for commission of crimes. Thank you very much. God bless us.
What's your inherent fears for this country and the jurisprudence, considering the fact that your successor has discontinued some of these high-profile cases, and what different will you have done putting you in his place?
Take it now.
Two more. Let's take two more.
So, Dr. Ayines Presser has received commendation because he decided to give reasons for entering Nolly Corsica. Your office argued that the Supreme Court in the Rivera football case. First, what is your view on that, on this approach? And second, on the issue of the aforesaid matter and your alleged conduct with respect to Richard Japa. Even though the High Court judge didn't find any evidence with respect to you asking Japa to testify in a certain way, questions have been raised as to why the Attorney General will speak to an accused person without his lawyer. And second, there were portions of the tape where you sought to suggest that he tell the court that he was unwell for the purposes of securing an adjournment. And these issues, people believe, are unethical on your side.
So if you can give us what the issue was about, especially what the court said and what the Supreme Court also ruled on it, if I heard you right. Yes.
Right. Okay. So I think the first question for the gentleman, what are my fears for Ghana's democracy as it was the entry of the process? First of all, I look at everything from the perspective of public accountability. It's very important that there's accountability for all officers who offices which are deemed to be public trust. So if you occupy a public office, you're supposed to exceed public power and authority. And therefore, one should have no difficulty at all handling for one's stewardship. So when persons are prosecuted for specific financial crimes, it assumes a greater importance because the importance on the use of the public purse, which they're supposed to be trustees of, and whatever. Therefore, as far as I'm concerned, there ought to be a determination of the merit of the offense that the person has been charged with. And it becomes therefore worrying when, after courts of law have established that it's a case for the public officer to answer in respect of a specific financial offense that the charge, and I think you are exercising discretion, evaluate evidence in his chambers, calls of counsel for defense, they say that indeed that accused person ought not to obey his defense and that the case is closed. It becomes more worrying when indeed the effect of that is to confirm what we call in law an acquittal, which is akin to a determination of no wrongdoing by the accused person. But that's a judgment that ordinarily ought to be passed by the court. So my view is that once an accused person has been adjudged as the case for the accused person to answer, there is no basis at all for an attorney general to sit in his office or his chambers to scrutinize the evidence and speak to counsel for the defense and say that the accused person ought not to answer. And even like confer an acquittal on that accused person. It's unquestionable. And I would think that there's actually sufficient basis for questioning of the provision in the Criminal Offences and Criminal and Other Offences Procedure Act 30, which effectively confers on the Attorney General's power to pass a verdict on crime that has been that the person has been charged with. But effectively, If that's the case, then it means all an attorney should do, especially, I had no hold of them aside myself. So, US allegations have been made against certain business, maybe without indices at all. I just can collude with Minister A and say, Minister A, let's quickly file a case against you in the court of Ghana. Once the case has been filed, we call a few witnesses, close our defense, and then close our case, call upon the accused person to open his defense. Once it starts, we enter a withdrawal, and the person would have been acquitted. And there cannot be a reopening of that case. Because once the person has been acquitted, it ends the matter. I think it provides basis for sufficient appeal, especially in all these cases. So there's a case that has been made, and the court held that civil opinion was a case for him to answer. Civil opinion and 2 others. They went all the way up to Supreme Court. They did not succeed. Same happened in a storm scene. Some counts, the court said indeed there was a case for him to answer, as well as Professor Ampofu, the same day that Atufosi was acquitted by the court. The same panel actually held that Professor Ampofu had the case to answer. Subsequently, I'll tell you what comes less than a year. The president has been questioned. So that's my view. It provides basis for abuse, and indeed you must look at it from the point of public accountability. And Attorney General, by the essence of such powers, effectively shield members of the public accountability. Then, commendation by viewers presence for the press conference by Dr. Yini. Yes, the Agogo Afoko matter. So we must make a distinction between legal principles of law and what may be allowed. Or what may be proper. So in the eyes of the law, the exercise of the power of no prosecute is not subject to questioning at all. So when the Attorney General contends in court, which I did when I was deputy attorney, that the then Attorney General, Madam Godfred, was not required to account for the entry of no prosecute. That position is correct. But no prosecute is one of the means by which the Attorney General controls the conduct of prosecution. And indeed, I find it a little bit innocuous because it doesn't result in acquittal of the accused person. It doesn't result in the Attorney General exercising the power to pass judgment and effect on the conduct of any accused person. And no prosecutor results in termination of proceedings. The future Attorney General who finds merit in the case can revive it and go to court. Indeed, the same Attorney General may even just want to reorganize and come back, which we did actually in the Afoko case. The entry of no prosecute was because he had arrested the second culprit in the matter, whose role was deemed to be crucial. The then Attorney General deemed it fit to commence proceedings again. And we did it. We didn't just enter no prosecute, but it was the person's crime. So I think that if the Attorney General decides to open up on the reasons for entry of no prosecute and withdrawal, well, it's something that is permissible, but of course it's not legally compelled. The Attorney General is not legally compelled to do that. And indeed, I have on many occasions actually issued press statements. As you want, the record shows I issued press even after the court ordered a mistrial in the Afoko matter and other matters in Spain. So it is something that I think that ought to be tolerated and ought to be encouraged. No. But the fundamental question is, what were the motives for the press conference? And as I've disclosed, the motive for the press conference was just to whitewash or just to explain. He himself knew that there had been a public backlash, there had been a reduction of the goodwill that they thought the NDC had in the beginning by the entry of these withdrawals and all that. The public was really appalled by the manner in which these withdrawals were done, especially when you put it in the news. Those were really the two motives for the hold of the press conference by Dr. Yini and nothing more. And regarding Richard Japa, yes. So I think that, as I said, the full facts were actually unraveled in the course of court proceedings. The tape was played many times. Even when Japa was the witness, the tape was played again. I proceeded to cross-examine him. The DPP had earlier cross-examined my allegations, affecting me personally, because I think that no, you cannot be saying things. I said this, I didn't say that, and that was. It comes to the DPP aside the I actually did conduct that part. The main cases, the main case affecting that part, I did that. When I was poisoning, he never even brought it up because he knew the allegations that were made in the media were totally false. The true facts are simple. I've never met Mr. Japa anywhere in my life apart from the courtroom and on a few occasions in the House of Justice, the Supreme Court. That is really clear. And that's because I have never arranged any meeting with him. I mean, Godfred is a very respected figure in Ghana, a former member of the same firm that I trained in Kusari Pepenko, and we had good relations before he became a judge. In fact, it's even important to note that the house that I live in, which I bought in 2014, I bought it from Justice Lady's clients. So we have had that when he was a lawyer, practicing lawyer, and I don't think he even wanted to go to school at that time. So we had that very good relationship. So a few occasions, maybe a Christmas party, Easter time, and that kind of thing, I'll go to Lady's house. Occasionally, he will call me. He had not seen a long while. I'm coming back. I'm coming. Then I met him on those few occasions. The interactions we had did not bother anything else. And indeed, on one of the visits, the very last visit, I knew that he was no one. It's a matter of record. In the record of proceedings in the court showed that even the day in question, his own counsel had called the DDP to arrange an adjournment because he knew his client was wrong. And the case came on, the judge asked the lawyer for the accused actually requested that they go into chambers and discuss matters regarding an adjournment. Again, because of the warnings of Richard Japa. And they went because of the warnings of Richard Japa, and adjournment was granted. Incidentally, that week happened to be the week just preceding an international arbitration I had in the United Kingdom. As a matter of fact, look at all the days ago. The hearing of the GC net matter, which subsequently the government of Ghana won, was on the Monday after the secret recording by Mr. Japa, which was on either the Tuesday or Thursday. So, and the international arbitration proceedings are so voluminous. And powers in office have cultivated the habit of conducting most international arbitration cases. Myself and my deputy were in Ghana. It's not about that I know we go other state attorneys. So the case against Mr. Japa used to come on Tuesday and Thursday. By the Thursday, if you are telling you are comparing a lot of work, cabinet, and security council, court, everything was trying to do it together. So on the very Thursday, Facebook, Thursday or Thursday, I realized I had to really prepare for the international arbitration. Otherwise, the hearing that was supposed to come up the next Monday, I would be very much in trouble. So, by 12 p.m., by 11 a.m., the matter was become 12 p.m. I realized that I was still not really ready or still. And that was it. Single phone call that I made to him, which was the serious matter of as we saw with I call him just because indeed I knew he was not. And that day, as I said, he actually went to court and got an adjournment because there was no work. I just called him in that conversation, not knowing he himself had that illicit agenda or secret recording. They were saying the things that he got on the tape, which they just said that those things, if you look at them, came from him and not from me. That's why I said, so you yourself, I mean, you know what, the day I met you. Is it possible? He said, oh, he's afraid because the judge had earlier on, it was a matter of fact, issued a bench warrant for his arrest. And so he was afraid to obtain or to apply for excuse from court proceedings on basis of being on court. I said, well, you can get a medical report. That's exactly what. Then he said, oh, it's a little too late, he's afraid of the judge. They went. And when they went, he actually obtained a judgment because there was no work. So the fact of my asking him to obtain medical certificate because there was no work was nothing but factual. Was not an attempt to get him to procure any evidence or anything at all. That is it. And then you asked about why did I speak to him in absence of counsel. I've told you exactly the circumstances that led to that, which of course he manipulated the law. And you will see that Ayini says he's consulting counsel for defense. The question is whether Ayini consulted counsel for defense in the presence of DPP and all that. Clearly, all those conversations Ayini had with counsel for defense, the DPP and co were not present, acting by himself. These are matters that. Anyway. I mean, the question. Right. On the perjury, yes, so I stated that the perjury application was ruled upon by the judge, and the applicants were the accused persons, and for that matter, the accused the court of appeal. So it is not correct that the perjury application was not determined by the court. And it is not even unusual for a trial court to say that the ruling on the application will abide the determination of the main case. If you are guilty, you can appeal, which they did. I don't think there's much. Right.
I work with the EIB group, GH1 TV, and Star FM. I want to fund our respect to the Sagleme affordable housing matter. The sum in question is $200 million. So Alhaji Colin Dauda and then the four others, unfortunately, one of them is deceased now. In the course of the trial, I remember when the very first prosecution witness mounted the witness box, Reverend Yao Osei. One of the issues that came to the fore was that if you look at the sum of $200 million, charges alone amounted to over $1 million. And therefore, on what basis are you charging Alhaji Collins Dauda to have expended $200 million when charges took away some of the money? Number two, Cocoa Board. One of the things that Dr. Ayini indicated was to the effect that prosecution called 7 witnesses to tell their story. Out of the 7, there is no end user, that is the farmer, who testified. Dr. Buni called 10 witnesses. Majority of them are farmers and end users. Come again? Yes, farmers. Seidu Agongo was in the witness board with its witnesses, and it was also calling end users of little bit liquid fertilizer. From the prosecution point of view and the strategy that the prosecution adopted, are these really, is there any of the evidence that the scientists were coming to by way of give witnesses or give evidence vis-a-vis somebody who has called end users of little bit liquid fertilizer to say that, yes, I built my houses when I used little bit. Yes, I bought my cars when I used little bit. If Dr. Ayini is saying that, continue with this trial.
Four financial laws, the sum of $200 million. Indeed, each of the financial laws offenses is built around a specific sum that an accused person can actually be held to a cost. So, Alhaji Kolidada authorized the payment of certain sums when he was office. They didn't amount to $200 million. Those form the size matter of offense of wealthy cost of financial loss. And as I say, it must be distinguished from intentionally misapplying public property, which is his authorization for the application of the whole $200 million for the construction of 1,412 housing units. When indeed Cabinet, Parliament of Ghana, and PPA had approved that the entire $200 million used to construct 5,000 housing units. So his directive wrongly an application of $12 for a number of houses is far less than has been approved by Parliament and by PP, resulted in him is being charged with that offense. So there's really nothing wrong that's been done in the other matter. We are charges. Perhaps you are calculating because each of the counts has specific sums with which an accused person can be linked. And then why did we not call Google farmers and all that? The Republic of Ghana, when it's prosecuting cases, has the benefit of properly trained scientists who can test to the efficiency or the efficacy of a little bit fertilizer, which we did. We called scientists from Ghana, create the Cocoa Research Institute of Ghana, as well as even sent a little bit for testing in Germany and all that. So the efficacy of that has been proven. There's also the opportunity to indicate whether indeed there was a direct link between little bit fertilizer and any increase in cocoa yield and water. So we do not need to call cocoa farmers individually to say, this one will say, oh, my farm is competent for the use of little bit. This one will say, no, it's not true. Little bit is not well for me. How do you really guarantee whether you use it little bit well? So this is a scientific matter. It's not for, with all respect, cocoa farmers. I have not cocoa farmers on my tree. My grandfather had this, so this is not an attempt to do not cocoa farmers at all. All my aunties and all treated with cocoa farmers. No, so we're not. But I'm saying that it's a scientific process. We go scientific. Right?
So my name is Prince Kuluga from Joy News. I have some few questions.
Can we make just two more questions because
Okay.
we've got to wrap up on time. So yours and then all other questions can be taken.
Okay, so Mr. Former Attorney General, how do you respond to claims that you are just seeking to hand down the current finance minister by a hook or crook? Secondly, in your view, do the state have solid grounding in all the cases that has now been withdrawn, and do we stand a good chance of winning all the cases? And just on hindsight, how do you respond to the OSP and the former attorney and the former finance minister Ken Furiata? Do you have any view on that? Thank you.
Is it different from the first person, the OSP and the current? Well, you said first person was current finance minister.
Yes. So you were seeking, there are claims that you were seeking to just hand down the current finance minister at forcing by the Yeah, and I want to react to the issue between the OSP and the former finance minister Ken Furiata. Thank you.
And then
good morning. Your word. There's a school of thought that believe that white collar crimes, it takes a very long time to adjudicate on it. People believe that if the pace has been quickened enough, some of these people would have been leaving behind bars right now. And because you drag the matter for a very long time, now they are getting their freedom and they are told the story back to you. What do you take on that assertion? And our second question, in the case of seafood, is it seafood? Blue Sea, sorry. The company made an attempt to make part payment. That the Attorney General rejected. I don't know whether he rejected or whatever. That was the news out there. Because people thought that would have taken the money and maybe later on pursue the criminal aspect of it. Why did you do that if you did that?
Thank you. My name is Kojo Jackson and with Joy News. The Attorney General has gone on record to state that these individuals against whom the cases have been dismissed were basically wronged by the state. Now, as a former Attorney General, how do you assess? Oh, by the way, he says that he will fight any attempts by these people who were wronged by the state to seek compensation. as a former Attorney General, how do you assess his chances of winning any such fight?
Right. So, for the gentleman who spoke about the ambulance fire being considered witches, that's essentially what I addressed in my press statement. I've shown that there were indeed sufficient basis for a prosecution of the matter. And it's worthy to say that the trial court had actually stated that it was a case for the accused persons to answer. The accused persons went on appeal and succeeded to a split 2-1 decision, clearly showing that even on the board for appeal, there are some who think that it was a case for the accused persons to answer. And so, how regard to that, was sufficient basis for the decision to test it, whether the Supreme Court. And I believe that the pronouncement by the Supreme Court will have both finality as to the culpability or otherwise of the accused persons, including the current finance minister. And because it is not uncommon for the Supreme Court to overturn a judgment by a court of appeal, as happened all the time, and all. And the basis are simple, as I said. The states engaged in transaction for the supply of ambulances. Certain vehicles reporting to be ordinary vans, in the words of the former Minister for Health, Dr. Adesina, were supplied. So the question is whether the state indeed received ambulances for the over 2.3 million euros that was paid for it. So the question of financial loss, no doubt, has been established. The next question would be, whose act led to the financial loss? Another question would be, the person whose act led to financial loss. When those acts willful, willful has been defined in various cases to include even negligence. We were supposed to do something in accordance with due process, in accordance with requirements that are going to not do so. That's it. The agreement required that the audit pre-submit inspection before. The Minister of Finance may not be the one for that pre-submit inspection, but it is the guardian of the public purse. The Minister of Finance is the one which pays for that public purse. Even when I was at Asia, many times we sent requests for payment for X, Y, Z, which the Minister of Finance will perish. Has not been in accordance with the budgetary limits and all that. So, before Minister of Finance authorizes payment, there must be satisfaction of the due process, and that due process includes that there must be a warrant, the basis for the payment. So, if an agreement has clearly not been to Parliament, has not received parliamentary approval, and indeed there was a commercial agreement between government of Ghana and a foreign entity doing business with government of Ghana. That agreement cannot even be said to be valid. But that was the opinion that was given by the Attorney General, the Deputy Attorney General, the then Deputy Attorney General, and Dominic Aini, that agreement which was a commercial agreement which has not been signed, commercial agreement which has not received parliamentary approval. Commercial agreement between a Dubai-based company and government of Ghana, which has not received parliamentary approval, has satisfied all the parliamentary or the statutory approvals. No, definitely was wrong. Apart from that, per the contract, the terms of the contract, the steps that ought to have been satisfied before payment will be due have not been satisfied. So, on what basis would the Minister for Finance or the Deputy Minister for Finance authorize payment? So, clearly, there was basis for charging the accused persons with offense, and I believe that if the appeal had not been done, the appeal would have successful. But it's up to the attention. You asked a question also about OSP and Mr. Fuyata. For me, I think it's also important to state that once in office, having regard to the requirements for independence of the social prosecutor, I never, on any occasion, interfered in the work of the social prosecutor. If you would notice, there was never a moment on which I met the OSP. I gave him complete independence to do his work. And that's because it's a requirement of law that is put in law. But of course, the OSP acts just like those of the Attenjura subject for scrutiny by the courts of Ghana. So the OSP does anything that will appear to be overstepping of his bounds, so that the courts can call into order, just like actions of the Attenjura all the time are questioned in the courts, and decisions by the president of Ghana are being questioned by the courts. I think that what happened this week between the OSP and Zaki Ofrata was rather unfortunate, because before the president can be seen to be avoiding the requirements of criminal process, it ought to be an account of that person having been subjected to a process before. And I read of correspondence between lawyers for Mr. Ofrata and the OSP, by which we did a period of just about 2 weeks. The OSP had been notified that Mr. Ofrata was sent to registration. And he has not registration since 3rd or 4th January. So it is not, and he went out of registration before the OSP started requesting the attendance of Mr. Ofrata. So it is not as if there was a request for the attendance of Mr. Ofrata at the office of the OSP. And then Mr. Ofrata told out of registration. They left the country 3 clear weeks before the request by the OSP was made. And once it was made, it was not ignored. Ofrata responded and stated to his lawyers that was out of registration. So I find the actions of the OSP the greatest threat. Everything on the street. I felt I could have avoided that. Maybe lessons will be learned, I'm sure. So that's what I can say. But as I say, you see how reluctant I am. I'm really all the time constrained to make it. I never made any statement at all when I was in office. I would do it. The only occasion on which we had to act was when he himself referred the matter to and Yoko sought our advice. Of course, even before he was referring the matter to Yoko, he himself had played this other part of his role. So then, white collar crime, yes, taking long to resolve. It's a very important question, and it is one that I sought to cure when I was in office. All the delays in relation to the prosecution of the various financial offenses can never be attributed to the Attenjura. We all in Ghana, we saw the defense, the counsel for defense resort to all manner of ways to delay matters. I can count as many as about 47 interlocutory applications filed by Dr. Singopuni, as well as about 15 appeals filed by them. And I think that it is a situation that the judicial service of Ghana or the judiciary must really deplore and not to take a serious view of it. Or many times I've complained about it in the media, the delay in the prosecution of these financial crimes. Because I recognize that if it is efficiently prosecuted, it will actually be, it will serve as a very, very positive signal for the country, because it will deter the perpetration of such offenses by persons who hold public office. And therefore, and it's also quite ironic that the NDC will orchestrate such delays only for them to come to power, discontinue the trials, and now, as I hear even in social media domain, some commentators will turn around to blame the prosecution for such delays. All the interrogatory appeals were filed by the accused persons. They filed applications from the High Court all the way to Supreme Court, and when Supreme Court rules, there will be a review of whatever. So, when I was in office, I sought to introduce a bill, which is the Criminal and Other Offences Procedure Amendment Bill, to ensure an expeditious intervention of all criminal cases. The bill went to Parliament, got through the second reading, and then the chaos in Parliament occurred, and the bill was not passed. I quite shockingly heard the new Attorney General express quite a bit of lack of interest in the bill at its vetting. And I'm surprised, because when Attorney General is supposed to really be in the expeditious intervention of criminal cases. He is the Attorney General now. Let's see what he will do about it. So, then there was a question by Mr. Godfred of Big C.
Big 60, okay. Why they made them to make some part payment?
Yes.
I'll get it.
Because we act in accordance with due process. The request was made by counsel for the defense. I will say that the company, which was not a party to a transaction, would offer to pay and the case to end. So the DPP, the Director of Public Prosecutions, wrote back to the counsel for the defense that this, by any implication, mean that you are submitting yourself to plea bargaining. There's a new plea bargaining law which I introduced again when I was attending. Are you carrying within the premise of that? And then they wrote back and said, no, they're not carrying that law. And so how are you going to do it? There must be now a law which regulates performance or the taking of every step by the prosecution. So that accounts when through prosecutions and all. But of course, now the government, the same counsel for the defense who made those proposals. In fact, even the third accused who made the proposal is also a government, which is a government, so you are saying you can pursue them for the money. So, I mean, the state should not be, should not suffer at all. So, could you answer this question?
Final question.
I think you was wrong.
The Attorney General has gone on record to say that these people were wrongly prosecuted. So the state has wronged them. He also says that if they seek compensation, he will fight. How do you assess his chances of winning in this?
Very high, because he knows that the prosecution was not malicious. The basis for such a claim by any accused person is when it's malicious prosecution. That's what we call a tort, a civil wrong, the wrong of civil. So the fact that the prosecution even fails, assuming that the prosecution is malicious. Malicious prosecution is when, without any basis whatsoever, file charges against an accused person, just to chat him up or to date him or to harass him. That's why you must be careful before you exercise prosecutorial authority. This cannot be the case when many of the accused persons are held by the court to have a case to answer. Okuni, Kusankofu, the Stormsy, and all the other cases. Because a chairman, even we are the submission of the stage, very discontinued. And the basis were clear, and I've shown from what I've stated that none of the cases can be subjected to the attack of malicious prosecution. So he knows that the chances of the success in those cases is very high. That's because our prosecution was not malicious. So I'm sure that you the first has to claim to dismiss.
Okay, ladies and gentlemen, thank you so much for attending on this press conference. I'm sure that the Honorable then Asunaba Dapa will take us through a key treaties and summary of
Attorney General, everybody are only in one. If you say, send your human city, and that's all my Attorney General, we are one shooting us to be an human. Now, a year Attorney General, Dr. Ayumi, now all withdraw cases, and I say, who said, Honorable Godfred, I'm the Attorney General, a day from the court. Or you have to court, not in moon shake, you move, but if you send. Ghana for P, FP almost share the same. A yet then a bonny exercise out before it again to a former Padan court, 2 year free court. Oh, Chiremuna, or yeah, and I can say, Lady Kind. 1 year a year judges for their attack home. Once I attack a year, Godfred again. Not a say, I said. Oba Emma Ghana for you to cry and walk the airport as saying, don't you didn't create any at all. Then one change and one for cases no one after the other. Now the kind was said or can say, Mushe Muya, a year a bra MPP are buying a buy a bed who mine. Now a case is being a etia a MPP 4 ministers near appointees. And one musha, a move be anywhere. MPP ba they decided say you pay this case in every court. Name MPP 4 lawyers age now court. A committee Miami cases in the mirror, but Fredami so yes cases needed. Causing financial loss case now. And yes, new attorney general or buy a year Yama Megloria any free court and I said Godfred free court. Name of your Congo court. Emma Bruni Becassi vindicated the rights of those accused persons. Emma the assembly could be my court to say Ampa. Where do Nigeria was I and before penny for me? Assuming in Australia. It's not a share who said, say you rap, age Yawaba free, so who would to me would Jimmy pass and this phone penny for this up where do I would do it. I won't. Say, oh, you're innocent. Nanka, with good faith now, as I will change. Now, Mom vindicate to right, as sure of innocent, send you over the years. Then, Nayera, age, a doctor, even our past, lawyer for Chechequest, Eka, or not yet, what did you two face the clients no, and anybody into one of your background setting. There no question I hear beside and say, let's just one or did you so innocent to make me up. Or more talk and walk out and say, and they would die one filing on the prosecutor. Now, when Jai assembly, they were more say, or need to not be a massam no any don't be before. And on our person, one up a poem bonnet. Now we will move this up. Now, of course, one year, Godfred Dummy, I checked a case in my giddy kind pa and Nunti, Ebra, age Ginaso, here Dr. Ine, said, we is answering for a baby. Every court, me up a poem of one in honey, I clear from Bonnie my say. A yet internal memo be office of the age, a year cracked office of the age, a year prosecutors or more age, and 2 Godfred Dummy for said 1 year case if you say in Jinabia. Then no, Enna, Era Dummy, I throw challenge say, some memo be any was an net, sir. Yera Lotta, Emma, that is also a memo saying in Godfred Dummy so bet share now, you know, women, some young 7 and now. Sad reasons we. It's reasons quite of Godfred Dummy so true was some men say, no questions some men will be your back. A whole custom now would do. Why do you go ahead go her name bed you know son? A be a your son. So who fat child back now say women who say effective to say a sample in the case. The question is, as I said, when they say other charges in account, the one campus in 2 strike here no one out, and then other charges in account, where do they count? And the one to us. The TTM one is saying, and then person Ghana for a crack, and in trad of no prayer, what yassam, and in trad Dr. Ine Abecha, our Hanusi. Now, Suswampa, as some mirror Godfred, I may kind of say, this same woman say, send your Dr. Ine person who said, Ghana for Yadisa. And Tessa, Nasa would dream home and see in some of the Kayano. Any day, yes, she had the response now. Who say a young truck and a doctor, you be a big now, and selling it, ever catch a gun. It's measurable. There is our press conference around said, won't hear the fact. Then it's our lump sum statements now one making. And as to the basis, our wings answer before. And Yano Craig, meaning now traps was said. A year NBC, a memo, NBC government, a year Dr. Ine as Attorney General. Nitipo Nina said, Bonia NBC for a corruption now, or made Ghana for Drew, NBC Cabin by Yavia. 1 year and actually NBC government, and yen actually said, or Ben Pins and Pins, name more the Kata so I'm on one in what the actual Madame was saying.